So there's a few other things that I'm going to mention here as well. First off, regarding the hearing that took place on September the 1st, 2022, the public was forbidden from entering the courtroom. And there has been, as we've said in the past, on March 13th, 2020, Judge Roy Ferguson gave the background and legal standards, the public right to access remote hearings during COVID-19 pandemic. They issued the order. And one of the things that he says in the order is this: if supported by appropriate findings made on the record, the court may limit attendance at the hearing to only those persons who have direct interest in the suit or in the work of the court. And I'll tell you what, I have direct interest in this, both in the suit and in the work of the court. But because the constitutional right at issue belongs to the public rather than the parties, all closures or restrictions of public access to such hearings must satisfy the same heightened standards handed down by the Supreme Court in Waller regarding criminal cases, even when agreed to by the parties. Thus, while the court may consider the parties' agreement, and I can tell you one thing, Mr. Younger did not agree to this. While they may consider the parties' agreement while evaluating a request for closure, the agreement alone is not sufficient to warrant closure. The First Amendment right belongs to the public, not to the parties. The parties cannot waive it by agreement. Furthermore, it is the court's affirmative burden to ensure meaningful and unfettered access to court proceedings. In fulfilling this burden, the court must take all reasonable measures necessary to ensure public access. I was denied public access, as there were many other people that were trying to get into the court. Judge Mary Brown intentionally closed down the court so that the public could not view what was going on, and I will have more about this in just a moment. Lack of access to a single hearing, suppression, or even a portion of a single hearing, such as voir dire, is enough to mandate reversal and a new trial. Furthermore, the court should not close the entirety of a hearing from the public view in order to protect a single witness or topic of testimony. Because the court must apply only the least restrictive measures to protect the overriding interest, only specific portions of a hearing or trial that meet this exacting burden may be conducted outside of the public view, and that only in rare cases. Appellate courts have reversed judgments when a single, less restrictive solution existed but was not considered on the record. I also have another piece of correspondence here to the 301st Judicial Court. And I want to go over this because this was actually sent by Mr. George Saldana of Texas 2503, which is a group that's been established that addresses the issue of interference with child custody, such as Ann Georgia has done on many occasions, such as Stacey Dunlop, the attorney, willfully overlooked, did not see. And when presented to him, that fact to him by me, he just like, he was like he was found out about this whole thing. Anyway, there are some requests that are here. This was an open records request made to from George Saldana, and this is the response back from Judge Mary Brown. So the request was, number one, I am making a formal request for the recorded hearing held yesterday, September the 1st, 2022 via Zoom. The host made the recording of the Zoom. Case number DF15-09887 was held at 2:30 p.m. The response by Crooked Judge Mary Brown was this: the official record is made by the official court reporter of the 301st District Court. For copies of the transcript, submit a request to Chantel Bahalir and gives Chantel's address. He was asking for a recorded hearing. And that is what we were expecting to see, but she ended up saying, well, she diverted the issues and she never answered the question. Instead of asking for the recorded hearing, which she does have, she said, well, you have to get the transcript here. Number 2, we're requesting the bailiff information, the bailiff's name, his contact information, and the phone number. That was all provided. Requesting the 301st Zoom rules, protocols, or Zoom COVID-19 operational plan. Judge Mary Brown, the lazy Judge Mary Brown, says, well, the policies are available on the court's website, blah, blah, blah. She will not answer the question. She is obfuscating the issue, and she's not answering the question directly. But of course, she gets to do this because she's a judge. Judges are never held accountable for any of their actions, at least they would appear in the state of Texas. Number 5, I am requesting any notice or order of the court that states the said hearing would not be streamed via YouTube. And Judge Mary Brown says, the 55th emergency order regarding the COVID-19 state of disaster signed by the Texas Supreme Court on August 30th, 2022, that has nothing to do with the request. Absolutely nothing. Mary Brown is not even answering the question. She is so brazen and bold-faced in her and just disregarding the questions. She's putting down something that has absolutely nothing to do with the request. I want to know about the notice or the order of the court that states the hearing would not be streamed via YouTube. There is no such thing. According to the background and legal standards, it must be made available to the public. But she did not do so. There was also there was also the request that the notice or order of the court that stated that the hearing would deny entry of the public and media into Zoom. Well, she says no such notice or order exists. So that's good to know, but then why did she deny the media and the public access to the Zoom hearing? We're requesting all judicial notes, memos, internal memos, stuff like that. She says all notes and memorandums are in the file maintained by the district clerk under cause number DF-15-09887 and are available for inspection by submitting a request to that office. No such internal memos or emails exist. Who knows? Maybe they don't. There are agreements, though. Coons Fuller is a platinum sponsor, according to Jeff Dalton, her campaign advisor or whatever. Coons Fuller is a platinum sponsor, and at least $5,000 was given to her. I didn't see the records, but that's what Jeff Dalton says, that Coons Fuller is a platinum sponsor. I believe I've also heard that a couple of people from Coons Fuller actually helped Mary Brown on various things. I don't know. I cannot verify that. But it's very interesting because I'm sure that there would be nothing that would be traceable or trackable as far as a written memo or an email or something along those lines. Number 8 was any and all memos, internal emails to attorneys about closing the Zoom to the public. She closed the Zoom to the public. Mary Brown closed the Zoom to the public. She would not allow people to come in. I know, I tried to get in. We were not allowed in. Mary Brown, I am sure, told her Zoom person, whoever it is, do not let the public in. No such documents exist, Mary Brown. Yes, of course, because it was a verbal order, wasn't it, Mary Brown? Number 9, any and all documents within Dallas County judges that are used to determine closing the Zooms to the public media. Standard operating procedures order the court guideline. And here's what Mary Brown says. Following a hearing in the spring of 2020, wherein a non-participant in the case exposed himself on camera, the court only admits parties, attorneys, and witnesses to the Zoom hearing. No such documents exist. Now, Mary Brown is actually lying because this also could have been broadcast on YouTube, and she has done many hearings on YouTube after that. I'm not sure whether I've gone to the Zoom hearings as well during that time, but she has broadcast repeatedly. She is lying once again. Judge Mary Brown is a liar. She is an unethical liar, and we're supposed to respect her as being a judge. Number 10, finally, any memo, order of the court denying media exclusively from the Jeff Younger case. The public was told no hearing was to be held, and this is what actually would happen, because at the same time when we were not allowed in, there were a number of us waiting. Media people, members of the public, other people that wanted to know what was going on here. And when we called in, we got several different answers. One of them said that the public was told no hearing was to be held, and this was by a court representative via the phone. The public was also told that it was in person and the litigants were in the courtroom, and that was a lie because Mr. Younger was at home participating via a Zoom call. So again, the court has lied about this. Judge Mary Brown has lied to Mr. Saldana about what took place there. And that was done again by a court representative via the phone. And finally, the public was told that it was being conducted by Zoom by a court representative via the phone. It was being conducted by Zoom, but Mary Brown is a liar and this whole thing was done illegally. And then she says at her response, no such documents exist other than the 55th emergency order regarding the COVID-19 state of disaster signed by the Texas Supreme Court on August 30th, 2022, which orders the court to conduct all proceedings in the court's usual location, which is 600 Commerce Street, Dallas, Texas, 75202. Mary Brown, once again, is lying because this hearing was held via Zoom. It was not held in person. Mr. Younger was not there in person. And I know by various means, I just know that that is the case. And many other people know the same thing. Furthermore, there's